Okay, everyone, welcome back for our final panel on prosecutorial power. And once again, I'll introduce our moderator and panelists. We have moderating this panel my colleague here at GW Law, Cynthia Lee. And Cynthia Lee, Professor Lee, is the Charles Kennedy Poe Research Professor of Law here at GW Law, and she teaches and writes in the areas of criminal law and criminal procedure. And after a federal judicial clerkship, she began teaching at the University of San Diego Law School, where she received the prize for excellence in teaching. She chaired the AALS Criminal Justice Section in 2008, and she's the author or editor of numerous books and is currently conducting research on reforming the law on the police use of deadly force. And she presented her most recent paper to the faculty about a month or two ago. And was a fabulous presentation, thought-provoking and engaging, as all her scholarship. And she's easily one of the most generous and brilliant colleagues I have. So thank you for agreeing to moderate the panel, Professor Lee. To her left, we have Professor Angela J. Davis, Professor of Law at the American University Washington College of Law, where she teaches criminal law, criminal procedure, and a criminal defense theory and practice course. She's received many awards, including the law school there's Pauline Rule Moore Award, the Faculty Award for Outstanding Scholarship, and the American University-wide Scholar Teacher of the Year Award. She's the author or editor of numerous books, book chapters, and articles on prosecutorial discretion and racism in the criminal justice system. Her most recent effort, Policing the Black Man, is tearing up the charts, as they say, and she's been on a nationwide book tour for that important project. Before becoming an academic, Professor Davis served as director of the Public Defender Service for the District of Columbia after having served as deputy director and staff attorney at PDS. And she clerked for the Honorable Theodore Newman of the District of Columbia Court of Appeals and earned her JD at Harvard Law School. To Professor Davis's left, we have Professor Adam Gershowitz and Associate Dean Adam Gershowitz, who is currently the Associate Dean for Research and Faculty Development and Professor of Law at William & Mary Law School. In addition to his traditional criminal law classes, Professor Gershowitz teaches a course that's close to my heart. His course on the HBO series The Wire is one of the most popular courses at William & Mary. And he's gone beyond where I am, because I just teach a seminar on that. He has actually authored a textbook entitled The Wire, which he uses in his course and is used at law schools around the country. Professor Gershowitz served as a law clerk to the Honorable Robert King of the U.S. Court of Appeals for the Fourth Circuit, and he worked as a litigation associate at Covington and Burling. And before he joined the William & Mary faculty, he taught at the University of Houston Law Center and the South Texas College of Law. He's written numerous scholarly articles and has won multiple teaching awards, including the Professor of the Year Prize at 3 different law schools. And he's a graduate of the University of Virginia Law School. To his left is Professor Daniel Richman, who is the Paul Kellner Professor of Law at Columbia Law School, where he teaches federal criminal law, criminal procedure, evidence, and a sentencing seminar. And he writes on criminal justice and federal enforcement issues. He is also taught at Fordham Law School. Professor Richman was an assistant United States attorney in the Southern District of New York. And he ultimately became chief appellate attorney in that very prestigious office. He was a law clerk to Chief Judge Wilford Feinberg of the U.S. Court of Appeals for the Second Circuit and to Justice Thurgood Marshall on the United States Supreme Court. And Professor Richman, in his scholarship, has a knack for distilling complex ideas and reframing them in a way that not only adds coherence, but illuminates that which was previously unseen. And he is a graduate of Yale Law School And again, we appreciate his presence here today as well. And last but not least, to his left, we have Professor Wright, who managed to be here all day, and I still haven't had a chance to greet you in person, but hey, how you doing, Ron? Ronald Wright is the Needham Yancey Gully Professor of Criminal Law at Wake Forest University Law School, where he teaches and writes about criminal justice. He's the co-author of 2 case books in criminal procedure and sentencing, and his empirical field research concentrates on the work of criminal prosecutors. Some very, very fascinating work looking behind the curtain at the work that prosecutors do in their professional formation and development. He's a board member of the Institute for Innovation in Prosecution, and prior to joining the faculty at Wake Forest, he was a trial attorney at DOJ, where he prosecuted white-collar criminal cases. And Professor Wright is also a graduate of the Yale Law School. And with that, I will hand it over to our moderator, Professor Lee, and ask you to join me in a round of applause for our panelists.
So we'll kick things off with Professor Davis.
Thank you so much, Professor Lee, and thanks so much to Dean Fairfax and to the Law Review for inviting me. It's been a fabulous conference, and I'm honored to be a part of it. So I want to use my time to talk about what I perceive to be the most pressing, difficult problem in the criminal justice system today, and that's the problem of mass incarceration and the related problem of the unwarranted racial disparities in our criminal justice system, and specifically talking about the role that prosecutors have played and continue to play in that problem. I really believe that our criminal justice system is in crisis. You've heard some of the statistics already. I'll provide just a few more. The United States has the highest incarceration rate in the world, with over 2.2 million people in its prisons and jails and 4.7 million people on probation and parole. The number of people in prisons and jails has increased by 500% in the last 40 years. In addition to the problem of mass incarceration, there are severe unwarranted racial disparities in our criminal justice system. People of color, especially Black men and women, Latinos, Latinas, and Native Americans, experience discriminatory treatment in the criminal justice system at every step of the process, from arrest through sentencing. African Americans are 2.5 times more likely to be arrested than whites, and 49%, almost half of Black men, can expect to be arrested at least once before the age of 23. Black men are 21 times more likely to be killed by police than white men. And remarkably, the number of Black men in prison and jail on probation or parole by the end of 2009 roughly equaled the number that were enslaved in 1850. Black men serve more time for their crimes than others similarly situated. Data collected by the United States Sentencing Commission between 2007 and 2011 revealed that Black men in federal prisons received sentences 19.5% longer than white men sentenced for the same crime. And of course, we all know the statistics with regard to the death penalty. How did we get here is the point. There are a lot of reasons, including the war on drugs, the passage of harsh sentencing guidelines, numerous mandatory minimum sentencing laws on the state and federal level, and I did walk the halls with Nikichi fighting that battle so long ago as well. The Anti-Drug Abuse Acts of 1986 and 1988, they created these harsh penalties for drug offenses, including 5 and 10-year mandatory minimum sentences for first-time drug offenders. At that time, mandatory sentencing guidelines that still somehow feel mandatory, even though the Supreme Court has said they are not. The federal judges don't seem to be getting that message very well. To the 1994 crime bill, the Clinton's 1994 crime bill that eliminated parole, funded more prisons, created more mandatory life sentences for individuals convicted of a third drug trafficking offense or a violent felony. So these laws were awful, right? Extreme, overly punitive, irrational, resulted in even people who committed nonviolent offenses being sentenced to decades in prison and sometimes even life in prison. But laws don't implement themselves. Prosecutors have played a significant role in the crisis of mass incarceration. These tough laws gave prosecutors the tools to fill the nation's prisons and jails, but none of the laws required prosecutors to charge every individual at the highest possible level, or even to charge at all. But far too many of them did just that. On the federal level, the charging and plea bargaining decisions are particularly significant. The federal sentencing laws require really lengthy prison terms, and before the Booker decision, the guidelines were mandatory, with only judges being allowed to sentence outside the guidelines if the prosecutor filed a so-called substantial assistance motion under Section 5K1.1. But many of the crimes also carry lengthy mandatory minimums in addition to those guidelines. So since so the problem here is that prosecutors, and the reason why I put so much of the responsibility on prosecutors is because I believe that they really control our criminal justice system, right? They, through the charging and plea bargaining decisions that they make, which they control entirely, they can almost predetermine the outcome of criminal cases, right? Why do I say that? Well, when we look at how our criminal justice system is run, it is a system of pleas. About 95% of all criminal cases are resolved by way of a guilty plea, right? Everybody looks at all the Law and Orders, about 8 or 9 of them, I think, those TV shows on television, and you think all these trials are going on, but there are not. There are a lot of guilty pleas going on, and prosecutors control that system. Since they only need to meet the really low standard of probable cause to bring the charges, much lower than the proof beyond a reasonable doubt that they have to meet at trial, it's very easy for them to pile on charges that they may or may not be able to prove at trial. And so you can see how a defendant facing multiple charges, sometimes with mandatory minimum sentences, might feel compelled to accept a guilty plea, even if he or she is innocent. And there are horror stories. One such story is that of Clarence Aaron, right? Clarence Aaron was someone who decided to exercise his constitutional right to a jury trial. He grew up in Mobile, Alabama, in a high crime neighborhood, but somehow managed to avoid the criminal justice system all the way until he got to college. He enrolled at Southern University, but when he was there, he made a really bad decision. He introduced an old high school friend to a college classmate whose brother was a drug dealer. And he was present during that drug transaction, and he got $1,500 for making that introduction. And he ended up being charged with conspiracy to possess a controlled substance with intent to distribute, possession of a controlled substance with the intent to distribute, and attempt to possess a controlled substance with intent to distribute. And he decided to go to trial. And he was convicted of all charges. He was a non-violent, first-time offender, but he was sentenced to 3 life sentences without the possibility of parole, just for introducing someone to a drug dealer. And all of the others involved in the deal who played a much more significant role than Clarence, they cut a deal with the prosecutor. They made it to the prosecutor's office before he did, testified against him. All of them received much lower sentences. His sentence was finally commuted by President Obama, but that was after he served 21 years in federal prison. And I ask you, in what universe is that justice? And it's on both the federal and state level. Many of you are familiar with the work of John Pfaff, who argues in previous papers and in his most recent book, Locked In, that the growth in the prison population during the 1990s and 2000s was driven almost entirely by prosecutors' decisions to file felony charges in state courts. Felony filings rose by almost 35% during that period of time, as did prison admissions, even though the crime rates and arrest rates fell. And he argues that it was the prosecutor's decision to file more charges that caused this increase. Now, when I was looking at the commission's report in preparation for this conference, it's a really interesting report. And I was just struck by the fact that there's no section on prosecutors, right? They do talk about prosecutors, but there's a section on juveniles, there's a section on the courts, there's a section on, technology, but prosecutors, the most powerful individuals in the system, there's no whole chapter on prosecutors that I found interesting, but they do talk about prosecutors. And one thing that they say about prosecutors, and I'll just read a quote, it says, "The commission regards the exercise of discretion by prosecutors as necessary and desirable. However, it has found that more often than not, prosecutors exercise their discretion under circumstances and in ways that make unwise decisions all too likely." It goes on and later on makes a couple of recommendations. It recommends that prosecutors should endeavor to make discriminating charge decisions, assuring that offenders who merit criminal sanctions are not released, and that other offenders are either released or diverted to non-criminal methods of treatment and control by the establishment of explicit policies for the dismissal or informal disposition of the cases of certain marginal offenders. Note it says marginal offenders. Early identification and diversion to other community resources of those offenders in need of treatment for whom full criminal disposition does not appear required. So there was a recommendation of diversion, although for minor offenses only. So what do I argue? I argue actually that prosecutors have an ethical duty to end mass incarceration. And when I say ethical duty, I don't mean just sort of a general moral ethical duty. I mean ethical as in the professional rules, the model rules of professional responsibility. And here's why I say that. So Rule 3.8 of the model rules, called the special responsibilities of a prosecutor, it addresses the ethical duties of prosecutors. The first sentence of the comment to Rule 3.8 states that, quote, a prosecutor has the responsibility of a minister of justice and not simply that of an advocate. And this comment imparts the same sentiment as the United States Supreme Court in Berger versus United States, when the court said the United States attorney is the representative not of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. And in addition to the model rules, the American Bar Association has established these standards, criminal justice standards, that serve as guidelines for prosecutors. There's standards for prosecutors, there's standards for judges, for defense attorneys. And they're aspirational, they're not enforceable, they're consistent with the model rules, but they actually provide guidance on a much wider range of issues than the model rules. And Standard 3-1.2b of the Standards for the Prosecution Function establish the same responsibility as the comment to Rule 3.8, the duty of the prosecutors to do justice. It says the primary duty of the prosecutor is to seek justice within the bounds of the law, not merely to convict. Standard 3.3-1.2b goes on to state the prosecutor serves the public interest and shall act with integrity and balanced judgment to increase public safety, both by pursuing appropriate criminal charges of appropriate severity and by exercising discretion to not pursue criminal charges in appropriate circumstances. A later section states the prosecutor is not merely a case processor, but also a problem solver responsible for considering broad goals of the criminal justice system. The prosecutor should seek to reform and improve the administration of criminal justice, and when inadequacies or injustices in the substantive or procedural law come to the prosecutor's attention, the prosecutor should stimulate and support efforts for remedial action. I can't think of more of an inadequacy or injustice in the system than the untenable racial disparities that we have here today and the overuse of mass incarceration. Many scholars have written about the prosecutor's role as a minister of justice. Bennett Gershman, Bruce Green, the late Fred Zacharias, Rachel Barkar, and others. Many others have contributed to the scholarship on this issue. And a consistent theme throughout all of their work is that prosecutors have a much broader duty than their role in the prosecution of criminal cases. Professor Michael Cassidy wrote a law review article called Administering Justice, a Prosecutor's Ethical Duty to Support Sentencing Reform, and he makes some suggestions. I suggest going even further than Professor Cassidy does. Here's what I think prosecutors need to do. I mean, they need to do a lot of things, but here are two of them. I really think that, number one, prosecutors must drastically change their charging and plea bargaining practices, right? Every person who commits a crime actually does not have to be prosecuted. We know that because prosecutors already decline to prosecute in a lot of cases, thereby creating a lot of the class and race disparities that we know of. But I suggest that they intentionally, mindfully, and affirmatively decide that they will charge individuals only when that person poses a danger to the community, that when it's necessary to protect the community. There are other ways to hold people accountable other than putting them in a cage. And we need to join the rest of the civilized world in how we deal with it. I only have like a minute and a half left, so I'll tell you what my two ideas are, and maybe in Q&A I can explore them further. One is that I believe that prosecutors must drastically increase the use of diversion to include all, and I mean all, nonviolent felonies, period. Drug offenses, property crimes, other felonies that don't involve violence or harm to another person. These diversion programs have been in place for years, but when you only use them with minor first-time misdemeanors, it has not made a difference in the problem, and it's not going to. And actually, there are prosecutors out there, at least one I know of, John Chisholm in Milwaukee County, that hasn't gone as far as I suggest going, but definitely has expanded diversion to include not just misdemeanors. And the second idea, and so that's on the front end. On the back end, I suggest that prosecutors need to support clemency in appropriate cases, right? So we know that prosecutors across the country have opened these so-called conviction integrity units, like Innocence Projects. There are a number of prosecutors that have done that. I suggest that they start clemency units in their offices where they take the lead in supporting clemency for individuals, certainly people who are in prison for nonviolent offenses, but even people who are currently in prison but no longer pose a danger to society because they are too old to commit crimes, for example, right? Why not take the charge, take the lead with governors, with executive branch? Prosecutors have a powerful voice in that lead. So I'll just end by saying, prosecutors do play an important, essential role in our criminal justice system. We need prosecutors to enforce our criminal laws, but they have to do so. They must do so fairly, equitably, and compassionately. We need prosecutors to do their duty to keep us safe, but oftentimes to protect society and keep us safe. And that oftentimes does mean seeking incarceration, but they shouldn't charge and lock up people just because they can. They should exercise their power and discretion with humility, not arrogance. They should use their power to do good. And today I think that means taking affirmative action, and affirmative steps to end this crisis of mass incarceration. Prosecutors have been given extraordinary power, and to that I say, to whom much is given, much is expected. Thank you.
Now we'll hear from Professor Adam Gershowitz.
So I'm thrilled to have been here. It's really been a wonderful conference, and I'm a little intimidated, I have to admit, with this group of panelists. And sort of to put the cherry on top, the guy who was my criminal procedure professor when I was a baby, Stephen Smith, just walked in the door to make it all the more intimidating to me. So, hey, Steve. It is actually really difficult to follow Angela Davis on a normal day. I think it's more difficult to follow Angela Davis when you're basically going to stand here and argue, I think I can help fix the mass imprisonment and mass incarceration problem in the United States by giving more power to prosecutors and more obligations. So I'm going to pitch three sort of smallish ideas that I think will help on the margins, but you have to sort of maybe accept the premise that we could give them a little more power, which there's good reason not to, I would say, that you've just heard and that many people have written about. So the three ideas that I'm going to pitch that are kind of related are, first of all, prosecutors should be pre-screening warrantless arrests prior to arrest and bringing someone into custody by the police. In other words, police should actually have to check with prosecutors before they check a person into the county or the local jail before they can do that. Second, and this should not be controversial at all, at the time when prosecutors dismiss a case, they should actually have to notify the police and explain to them why the case is going to disappear in the thought that that's actually going to teach the officer something. And third, in doing that and doing it in writing, prosecutors should keep a database. They should keep a database along the lines of what Brandon Garrett talked about earlier with data collection that tells us who is messing this up and what we can do about it to train them in the future. So sort of as a starting point, criminal codes are very broad. Bill Stuntz has taught us this a long time ago. A lot of arrestable offenses, and the Supreme Court only requires a warrant typically to arrest in the home. So most arrests are going to be done without a warrant. And so it's the police, it's not the prosecutors at that stage, but it's the police at that point who are deciding who gets picked up off the street. The only real restrictions on that are a pretty low probable cause standard and a requirement that there's going to be a hearing 48 hours later, which is a long time if you've been locked up in jail waiting to find out what's about to happen to you. And so we could expand this more deeply, but we're pressed for time. So the general gist of it, police have a lot of power to start the machinery of criminal justice. You could provide a lot of citations for that, but because this is a Roger Fairfax sponsored event, I'm going to provide the following statement from Detective Jimmy McNulty from The Wire, which is that you can lock a guy up on a humble, you can lock a guy up for real, or you can pull under the expressway and drink yourself to death and your partner's going to cover it, because no one, according to Jimmy McNulty, and I mean no one, tells us how we're going to spend our shift. from season 4, episode 10, if you want to use it in class.
In the second half hour.
That's right, but just barely in the second half hour. So, should that be the case, that we let police have that amount of discretion in a situation in which we think the prosecutor should be calling some of these shots? And so, to look at the prosecutorial involvement at the stage of arrest, I tried to do the kind of work that Ron Wright does so well. I contacted 100 counties around the country and said, I want to talk to you about what you advise the police at the moment that you conduct an arrest. Actually, I spoke to my wife, who was a former prosecutor. I said, do you think I should go in there and try to interview them the way that Ron does? And she said, you're more of a guy who talks on the phone. So you're kind of less likable in person than Ron would be. So I actually did end up speaking with about 40 prosecutors in counties around the country. And what you basically hear from them is it is very rare for prosecutors to offer advice to police at the moment of arrest. And so they have call-in lines, they have hotlines. Sometimes in murder cases or domestic violence cases, it might be required in a small number of jurisdictions. But by and large, cops pick people up off the streets and the prosecutors hear about it later. And they are not calling the shots on that, with a few exceptions, which you can sort of dig into if you wanted to read further. Prosecutors tell you they're not involved because they don't have time for it. They don't have money to staff people to do this. And then also because they're real concerned that they might lose their absolute immunity if they start performing an investigative function, which I think is an objection I find incorrect, but they do seem to really believe it. There are problems, I think, with ceding responsibility to police. Even if Ed Chung, I don't see him here, but he would want to earmuff it if he were still here. There's problems with ceding responsibility to police for things because they're not well legally trained, and allowing police to have a lot of unfettered authority creates problems in what we might call weak cases. And there's a fair number of weak cases in the system, and we know this, Ron's written about this, because a lot of cases get dismissed. Some get pled out, the way that Professor Davis explained, but a lot of cases get dismissed. And so we see, and if you talk to prosecutors, they'll tell you that police will bring in cases that are weak cases. They are resisting arrest, evading arrest, terroristic threat because they yelled at the officers, loitering, where police want to clear a street corner in New York City or some other large jurisdiction, cases where it's difficult to prove, or cases where just the officers think arrest is merited, but the prosecutors might disagree. And consistent with the discussion that Professor Mears and Professor Henning had this morning, I talked to prosecutors who will tell you the SROs in school were willing to arrest people, kids who were engaged in fights. I'd never heard one where someone was robbed of their cell phone from their boyfriend, but all those kinds of cases, and prosecutors turn around and in some instances dismiss those cases. And so there's concern that police bring too many cases in the door, and that they don't really vet them as well as we would like them to have done. And that causes problems for the systemic situation where everything is overburdened for prosecutors, for defense attorneys, along the lines of what Professor Marcus talked about, but tremendous problems for defendants, right? We're talking about mugshots. We're talking about people who are often poor having to post bail. We're talking about job loss due to incarceration, lots of wrongful guilty pleas for people who just want to get out and go home, and just systemic problems across the board that come with prosecutors having to dismiss the cases later instead of on the front end. So staggeringly, there actually is a large jurisdiction in the United States that does vet these cases at the moment of arrest. So if you look around in Harris County, Texas, in Houston, they don't do a lot of things correct in Harris County. I lived there for 7 years, but they do seem to do this correctly, if you ask me, which is they run a 24-hour, 7-day-a-week intake office in which no one, and I mean no one, is incarcerated in Harris County, Texas, without the police officer having to vet it and go through the prosecutors and get approval before putting that person in jail overnight or something like that. Cost them $6 to $7 million a year to run that. It's an enormous staffing obligation, but it clears cases out of the system before they are in. And so that's an instance in which you give prosecutors that power on the upfront scenario in which they will actually vet cases and remove them before the bottleneck occurs and before they're forced to dismiss them later. And so there's limited data on the success of this, although there's a few unpublished studies that seem to suggest they dismiss a lot fewer cases later than other comparable jurisdictions do. And so to the extent that counties are looking for ways to prevent overcrowding in jails, to prevent having to take in weak cases, that's something that places would explore. It's expensive, though, and that's the kind of thing where money spent up front might be money that's not spent on the back end, or money not spent by criminal defendants who don't have it in the first place. And so I went and I tried to sort of model what Ron does. I hung out there for the day and for the night, and you see remarkable things in a jurisdiction that does that. I offer a lot of examples, but I'll give you one that's just sort of a legally technical example of what they did there. I heard the phone ring, and the police officers, one case that I heard and one that happened earlier in the day that I did not observe, where the police officers wanted to arrest a guy for being a felon in possession of a weapon, which is going to result in incarceration. And in both instances, the prosecutor said we cannot arrest for that reason because that person is on deferred adjudication, which means under the Texas statute, they can't qualify for that statute. But those police officers, trying their best, did not understand that. And it took me a while to go find in the code where it actually said that. And so that was a guy who would have spent multiple days in jail, who the case would have been dismissed anyway. And so there are a fair number of cases like that that occur. So one suggestion, if you want to empower prosecutors to try to eliminate mass incarceration, is to reduce the amount of arrest that police are allowed to do by forcing them to vet their cases through the prosecutors. It's a fascinating thing to go and observe because most of the calls for that would come in orally over the phone, but occasionally I would see sheriff's deputies and constables and other police officers actually walk into the DA's office and say, we want to file charges on this, will you allow us? And it looked a lot to me like when my 8-year-old tells me he wants more M&Ms. It was like a police officer standing there really, really wanting it. And the grown-up saying, well, we're not going to have that. Although in my case, if it gets him to bed faster, I will do it. It's a situation in which prosecutors have a lot more control than you would expect in other situations and appears to work successfully. If you can't get a jurisdiction to buy into that, and most large jurisdictions have not, when I pitched that idea to people in Los Angeles and Detroit and elsewhere, they told me it was insane and that would never happen. And they were surprised to know that it does go on in a large jurisdiction. There are smaller things that could be done. And so in a paper that I'm going to publish for this journal, for this, what I thought was a fabulous symposium on this topic, police in some jurisdictions try to use dismissals as teachable moments. So if they dismiss a case on the front end after arrest, after incarceration, but before we progress too far into the system because the police officer misunderstood the criminal code, because an element is missing, because the search was invalid, because the confession is not admissible, or just because the prosecutor thinks this kid doesn't deserve a criminal record for having a schoolyard fight with somebody else, they notify the police of that explanation of what happened and tell them, we're not going to take that case forward. And so in talking with about 20 other jurisdictions, this is why it shows how hard it is to do what Ron did. I did the front end of this and I asked those 40 prosecutors and then I said, I have some follow-up questions. And then by the time I did that, I was down to 20 because they were tired of me by that point. But I talked to those 20 prosecutors around the country and a lot of them do use dismissals as teachable moments. They instruct the officers, some of them do it in writing, but surprisingly, there's a number of jurisdictions where when prosecutors dismiss a case, they never tell the police, and their explanation is, well, the police will figure it out at some point when they don't get called to testify at trial, so we just assume they understand why the case disappeared. That's, I would submit, quite naive, I would think. So informing police of dismissals, I think, is a best practice, and there are ways to do that that are likely to be successful. Do it in writing, make it mandatory so the prosecutors can't sort of squeeze their way out of it, and state the reason for why the dismissal is. And it may simply be, you don't understand the Fourth Amendment, that search is not sustainable. If you do it in writing, and this is the last idea that I'll pitch for you, and a little bit controversial, I think prosecutors probably would not want to do this, there should be a database of dismissals. And when prosecutors dismiss cases because police have erred, if you live in Mayberry, I suspect all the prosecutors in that jurisdiction know that officer, I never watched that show, but officer, there you go, thank you, that they all know that that officer is a problem or is bringing in cases that shouldn't or really needs training. But if you live in Houston or Dallas or Chicago or Los Angeles, where there are thousands of officers and in some instances, hundreds and thousands of prosecutors, they don't really have a good sense of who the problem folks are. And so if you create a database, what would that database show? Well, it would show senior officers in the police department. This officer might not understand, this precinct might not understand or care, or we, as a general matter of the police department, don't particularly understand a particular type of offense in the code, and we should try to teach police that they should stop incorrectly arresting for that. I suspect there'll be a lot of resistance to prosecutors keeping that kind of database because I suspect most prosecutors would say that that's going to create Brady obligations for them that they didn't have before. But I don't think most of that stuff is Brady material. And even if it were, we'd kind of like for them to find and root out the wrong type of police officers in the first place. And so a third solution, I think, is to create that sort of rigorous database, use it as a training tool and a disciplinary tool if necessary. And if it occasionally results in some Brady material, well, then so be it. And so I think there is room in the system. I think Professor Davis is right, probably almost all the way across the board about prosecutorial power. But bizarrely, I think there are a number of instances in which if we were to take small nuggets of ability to place power in the hands of prosecutors, we might actually do something towards curbing a little bit of the mass incarceration problem that we have right now. Thank you.
Next, we'll hear from Professor Richman.
Thank you. It's great to be here. I'd like to thank the law review and Dean Fairfax. I'd also like to thank you all in the audience for being here. It's Friday afternoon, last panel of the day. I'm not exactly clean up, Ron will be, but hopefully I'm sort of gonna warm up the audience for you a little. Now, actually, I'm not gonna warm up the audience in the sense that I wanna dial down things a bit. There is a huge importance. We really need broad statements of reform. We need to think about criminal justice as a single thing to be challenged and thought about as a nation, but not when we get inside of law school and we start talking about how to really fix things. I think mobilization is key. I think getting reports done is important. Just to shout out, one of the things that bugged me all through this conference is it's about 50th anniversary, but there's a reference in 1931. Just before 1931 was the Wickersham Report, which was also an awesome report that if you read it, will tell you many important things that need to be accomplished in the criminal justice system. It reads quite well. If you look at the staff of that and the commissioners, they were the leaders of the field in the years thereafter, just as those involved in this commission were leaders of their field. These are not unimportant. And I was actually just reading an interesting article by Lawrence Sherman about evidence-based policing and what the uptake when it comes to good thinking about policing comes. There's no straightforward transmission band between the doing of the work and the effectuation of the programs suggested by the work. It's done, it lies there, it gathers dust. Those of us in academia and hopefully in other reform areas think about it. Crises will come. With the crises come a need for good ideas to address the crises. The crises are exogenous rather. But they will come. That's the one thing we know in this area. So the doing of the work, the having of these conversations is critical. So even though I'm not going to be very inspiring in my preaching, I'm going to dial down the rhetoric a lot. I think it's for the good in the long run. Also for the good in the long run is thinking about who's in jail. One of the things that, as somebody who's focused a lot on the federal system just because I like small places to play in, one of the things that disturbs me most is when we automatically scale up from this odd boutique system to the nation. Drug crimes are not driving the size of our prison population in the United States. They just aren't. Violent crime is. John Pfaff's book does a lovely job of taking this apart. The federal system is different. There is a domination there, at least of people in federal prisons, of drug charges. But outside of there, it's violence. And this isn't to say we should put aside the need for reform. It just means we need to trudge and we need to be more thoughtful in making arguments because we need to connect with the realities in the prisons and to really come out and say people should be going to jail for less time for violent crimes. If you can't face up to that, you really can't have a useful conversation that goes beyond some boilerplate that will, work well at the beginning of a conversation, but hopefully not at the end. Another thing we need to discuss is that some people really ought to be in jail. One of the things we're starting to focus on in the last couple of years is, yes, crime rates are down nationally, but as Jeff Fagan and I just wrote a piece in the Columbia Law Review about the homicide spikes in the last couple of years in, St. Louis, Baltimore, New Orleans, Milwaukee, as well as, of course, Chicago. There are some people, and the clearance rates in these cities are miserable. More people who do killings ought to be in jail. Now, this isn't a retrograde message. The way you solve homicides is by having a smaller and less aggressive footprint in the community, and actually getting to know the communities you serve, having less aggressive police tactics against very low-level crimes or even not so low-level crimes. Solve the homicides, get the bad guys in jail. Their sentences will have to be higher than you're used to. But again, unless you face up to what we're actually seeing now, it's going to be a very hard conversation to keep going, particularly as the winds are against us these days. Another plea for disaggregation is we need to think about counties. And I really like Ed Chung's piece about all the different counties. You look at this and say, who the hell would set up a system this way? That's our system. We live with it. It comes with some spectacular downsides. It means you can't move forward and have large-scale reform activity led by Washington or even led in a sectional basis. It's even hard to do it statewide. That's a challenge. On the upside, it means each county really can be different, and there's spectacular variation across counties. We were talking at lunch, and I didn't have the numbers at me, but if you look at California's three strikes law, just radical differences across counties on how they're used. If you look in New York State has two criminal justice systems. Downstate in New York, there's basically been a de-incarceration statistics. If you look across from 1991 to 2015, the prison population sentenced from New York City goes from 45,000 to 20,000. Meanwhile, those sentenced in the rest of the state goes from 20,000 to about 20,000. Actually, it spiked a little bit in between, but no change. So if you look at New York State, it doesn't look anything like New York City. And one of the things I am not going to do, as we discussed at lunch, is say how they figured out how to do that in New York City. I'm not quite sure. One of the things we always ought to be careful about when we hear about progressive prosecutors is to beware of the branding of special programs that get touted out in conferences like this, and we celebrate the prosecutors for their doing good. And not much changes in terms of who gets prosecuted for what on the ground. On the flip, you have an office that actually has a bunch of offices in New York City across the different boroughs that have changed what they do. How exactly have they done it? And I'm sure there's huge variation. Staten Island is not even a part of the United States as far as I'm concerned. Never mind. So once you take apart the counties, A, it gets messier, but B, you start realizing we can do things about this if you start at the county level. At the county level, what do you see? You see a lot of different things. I'm sure there's some commonalities. I am sure that there are overcharging problems of the sort that Angela was suggesting in every office. I'm not positive about the mechanism for it. One of the things that always bugs me is people trying to come up with a utility function for prosecutors. What are they maximizing? They're not maximizing putting people in jail all the time. They're certainly not maximizing guilty pleas. People desperately want trials in a country where trials are a vanishing species, and there's an amazing amount of human capital that one can get at a DA's office by actually having a trial. You could just as easily say a self-dealing model would lead to overcharging, or even worse, charging innocent people. How this cashes out, hard to say. So let's assume that there is some overcharging, but let's at least be a little sensitive to the mechanisms of it so that we can deal with it. I mean, one way we can deal with it properly in the aggregate is to think harder about how we deal with recidivism. If you look across offices, this is where I think John Pfaff is good. Why are prosecutors moving to felony charges more lately? And why is the move to felony charges cashing out in a way that really does aggravate the racial disproportionality of punishment? A probable reason is criminal records. Communities that, particularly communities of color, are going to be over-policed, particularly in urban areas. All kinds of contacts with the police will happen. Those are going to lead to a level of arrests, not necessarily incarceration arrests, misdemeanors, maybe some felonies. You won't even necessarily go to jail. But in a shorter time, it will be more likely that that person will be presented to a prosecutor with a long rap sheet of not just arrests, but of convictions. And, you know, in the old days, or even now, some of the troubling rhetoric is, well, we should only be nice to people without criminal records. Again, you have to face up to the fact that our charging approaches when it comes to people with criminal records should be real, but thoughtful. I don't reach for the ethics rules. I always get scared when people reach for the ethics rules, just as, you know, when the white-collar bar tried to reach for the ethics rule to protect white-collar defendants, it scares me. I think public policy should be done outside the ethics context, but that's almost a matter of taste more than anything else. The last thing I'll do is make a brief pitch, again, trying to keep you awake, a brief, not totally convincing pitch against transparency. Here's what I mean. So much of the focus has been and should be on data collection, the generation of data collection and the use of data collection. Data collection does not create things automatically. Data collection sometimes can be used as a basis for mobilization of community activity or mobilization of political activity that will lead to change. More likely, data collection leads to ammunition for those forces that already have power. You look at the handing out of stop and frisk tickets or the collection of data with regard to stop and frisk. Again, a really nice criminal justice intervention that allows us to see what the police are doing. Then you look at how it's being used, you know, in Los Angeles. So it's just an interesting study done. Stop and frisks are being used as data that contributes to the likelihood that you'll be stopped again. You know, there are really nice databases the police have, and the data gets used by those that use data best, which is not public citizens, probably not most reform organizations, but internal bureaucracy. Similarly, when it comes to the idea of tracking dismissals, some of the dismissals, a lot of the dismissals might be for just dumb policing or lack of understanding of the law. Many dismissals, though, aren't. Many dismissals are because the police, for the reasons we saw before, are on a different page from the prosecutor's office. They're doing their thing because of their political accountability, and the prosecutors are doing their thing. You make that visible, I don't know what will happen. There could be a really nice conversation going, and I really like the idea, and I've written about this mutual monitoring that you could have between police and prosecutors that will lead to really interesting deliberations across cultures. Or you could have the police department that sees its officers arrests on a whole lot of policy kinds of cases being dismissed. We'll go to the DA, and I don't know who wins this fight because I haven't seen the county and I don't know the allocation of power between the DA's office and the police, but I could easily see the police winning the fight and that exercise of judgment by prosecutors' offices really being overturned by a police department. So again, transparency and data, really important, but think about who uses the data and frankly, join in the use of the data. That's also something that people outside can do. The federal sentencing guidelines are another great example. We made sentencing, this black box operation, visible in federal sentencing. We have grids, you can see what to do. You can change the numbers to affect sentences. So of course, Congress changes the numbers. When you have visible grids, when you have even prosecutorial guidelines, they're really nice for accountability purposes. But accountability to who and in what way is the question you should always be thinking about, because the most likely exerciser of accountability is going to be a legislature, or it's going to be voters in the one case that they pay attention to the election. I am not sure. So so much of the talk in the United States is about the importance of transparency and accountability. Yet at the same time, we say, oh, look at the places that really do criminal justice in a much more deliberate and thoughtful and moderate way. Those are not countries that embrace transparency the way we talk about. Those are bureaucracies. There's a high level of accountability within the bureaucracy, but in terms of spewing out data that can be used by outsiders, less so. So again, this is hard. It's supposed to be hard. I'm not setting up for another commission in another 50 years, but it is that, you shouldn't be too disheartened now. Eric Holder didn't change even within the little federal system. He didn't accomplish that much. He started late and he didn't accomplish much within it. I doubt Sessions will be doing much within it either. These things keep rolling along, and sometimes we should celebrate the fact that this is not very accessible to quick political change, and this might be one of those times. Thank you.
Our last speaker is Wright.
Good afternoon, everyone. And I stress the afternoon and the good part. I mean, could it be any better than being indoors on a glorious sunny Friday fall afternoon to talk about prosecution? Well, I'll tell you one way it could be better. We could talk not only about prosecution, but about paperwork in prosecution. That's what I want to talk to you about, is the paperwork. I went back to the 1967 report and just started reading. And one thing really struck me about the 1967 report, and that was that they were really interested in making prosecution more transparent and more standards-based. They were all pro-transparency, and they were pro-standards-based prosecution. What they wanted was for the individual prosecutors, there was no real vision of an office sort of structuring anything, but individual prosecutors in this vision should be more like each other and should act on the basis of a written record and then once they take action, they should create a record so that someone could come along later and reconstruct what they did, talk with them about what they did. It's prosecution on the record, as is the vision of the 1967 report. That's obviously not where we are, but I thought it was remarkable that that vision of recorded prosecution decisions was really so central to what they were talking about. Now, why do I say it's remarkable? I think it's actually very attractive in some ways. There are some pros and there's some cons to it, but I think on net it's a good thing if you can look over the shoulder of the prosecutor and reconstruct what he or she did. By the way, in the 1967 report, it's always him and the man, but okay, it's a good thing if you can look over the shoulder of a prosecutor and reconstruct what he or she did, because otherwise we're stuck with blind movement of the system. That is, prosecutors, in a phrase I've used in another setting, are always flying blind and flying solo. That is, they're flying around, they're up in the airplane, and they don't have the data to know anything about the map below them or how the plane is operating. They just don't really know much about their operation. And they're flying solo because others can't look in and say, oh, I noticed this trend about what you're doing, and maybe you should, tack more to the east or to the west or something. At the end of the day, if you don't have on-the-record prosecution, then if you say, do this differently, the answer is always, look, you had to be there. It's all about the case. I was the only one who was there. And so you can't second guess what I decided about my case unless you were there. Come along for the ride next time, and maybe, we can talk about what I'm doing, but you can't second guess me unless you were there. That changes if you have a world where you can reconstruct what happened. You can look over the shoulder. You can look at long-term trends. You can get some idea of what the reasons were for doing any one particular case. So that's why I think it's remarkable and promising, this vision of a greater record for prosecution that allows for spotting of trends and allows for conversation about different ways to do prosecution other than you had to be there. I'll give you a couple of examples of this. One of the recommendations from the 1967 Commission was that if you're going to do a diversion, we need to do more of them, as Professor Davis pointed out from the 1967 report. It does recommend heavier use of diversions for some kinds of cases, but it says the reason we haven't done enough is we don't have enough information. What you need is to be able to collect into the file. This is a very European kind of model, right? You have to collect into the file the basis for the decision, and then on that basis, you can make smarter choices about diversions. So we want greater factual records to explain to prosecutors in the moment and then to reconstruct after the fact. Why would you ever divert? You can build it from the record. Another possibility, and here's a little bit more on what the report calls the administrative record, anticipating our discussion these days about the criminal justice system being an administrative system where the prosecutor really is the key figure and the judge is just there occasionally to intervene to enforce legal limits. So from the plea negotiation section here, we talk about once the charges are in place, we need again to build the file so that we'll have information from referral and diagnostic services, probation reports, not in every case they say, but some kind of pre-sentence report to support the plea negotiations, not waiting until after sentencing. The report also talks about the standards that the prosecutor's using being on the record. That is, you don't just say, hey, prosecutors, I've hired you. There are 90 of you in our office. I hire you because you're professionals. Go out there and do the right thing, which is very attractive. And there are some offices that do that actually produce some very nice results. But in this vision, it's not just everybody's a professional, do your own individual professional thing. It's we are going to tell you what our priorities are. We're going to declare them. We're going to put standards out there for you to measure your work by. And that was something that was central to the recommendations in Chapter 5 about courts, not about prosecutors, of the 1967 Commission. The Commission also talked about checklists, not so much what substantive standard the prosecutor has to hit, but what kinds of things do you want the prosecutor thinking about every time? And then is there a record where the prosecutor goes down and says, yep, thought about that, yep, thought about that? So you're recording along the way who you should be consulting, what data sources are relevant, what needs to go through your mind as you're deciding how to resolve a case. Again, make a record of your thought process. And then finally, put your results on the record. So as you are negotiating, you need to put into the record the things that you consider and the offers that you made and then the offers that they turned down and then the offer you came up with. So putting the results on the record is part of this vision. It's remarkable. No, I'm going to keep that here. Some of this has come to pass. Some of this is the way we do things now. So if we back up to the factual records for diversions, if you look at a typical file today in state court, it's going to be richer than the typical information that was available to a prosecuting attorney in 1967. There's going to be more in the file. You just think about body cams or dash cams from the police. I'm going to be able to click a button and I'm going to be able to see a lot more about what happened in the field. I probably have not consulted medical experts and the sorts of things that the commission had in mind, but I'm going to know more. Right? There's going to be a thicker record today than there was in the past. As for standards on the record, again, if you look at state criminal justice where the real action is, it's an exception rather than the rule, but there are some offices that will declare these kinds of cases are our priority, these kinds of cases are not our priority. Push these as hard as you can, drop those or reduce them or don't spend resources on those. And it's declared in the standards, but again, exception rather than the rule. Very often it's just typically now in state courts, you show up, you see the prosecutor's office, and they don't have a manual of stated standards as the typical thing you run into. Same thing for procedures on the records. It's interesting that the U.S. Supreme Court has given us a little bit more of this put your results on the record, because we have, Missouri versus Fry and Lafler versus Cooper and from 2012, and they say it is possibly a ground for ineffective assistance of counsel if you have not explained to the client what the deal is, this set of decisions has given prosecutors and judges more of an incentive to create a record, to put in the file routinely as a matter of writing. I offered this, they turned it down. I offered that, they turned it down. We came to an agreement on this, but then I changed my mind, whatever it is. You have a written record now that really has been prompted by the U.S. Supreme Court. So that's one area where I could say, if it's not a rule, at least it's moving toward becoming a rule in state prosecutors' offices, that we do have a record of the outcome. Going forward, what might the possibilities look like for creating a prosecutor record? I tend to get sort of goofy and optimistic on this stuff because of technology. Because, look, it is possible now to create such an amazing record of everything that's done in complicated professional settings that just was unthinkable, 20 years ago. I think of my grandson, who is yes, I have a grandchild. I think of my grandson who is in daycare, and his daycare provider keeps an app. I, as the grandparent, can sign in, and I can say, wonder what's going on with Leo today. And I get, a 20-entry readout about what happened in Leo's day, including what he ate and then how he disposed of what he ate and when he napped. And I can reconstruct his day. If that woman who is taking care expertly of 6 children can keep that much data about what she's been doing during the day, I'm pretty optimistic about what a prosecutor could record about what's going on in the cases and what I did, and let me get my app out and tap in, what we have just talked about. It seems to me that we do have some real capability. It's not beyond us now. The question is it worth it? Would we get anything out of it? And I think that's where the user question comes in. Are you using it for internal management purposes? Are you using it for external accountability purposes? Probably for both. Which of them have the most promise? Which of them would call for us to keep what kinds of data? For me, I think the most promising forms of data don't show up in the 4 categories that the 1967 Commission focused on, because that was all about the individual prosecutor. What is this one guy, in their view it was a guy, what is this one person doing in this prosecutor's caseload? But what I'm more interested in is users that would be looking not as individual fungible prosecutors, but instead looking at the sociology of it, looking at the office. What is the office policy here? And can we shift the office policy from A to B? What does it mean if you have a new prosecutor who promised something in the election and comes in and is trying to do something new? Is that new juvenile program really making any difference at all, or was it just a bell and whistle during the election campaign? That's something that a prosecutorial record might be able to address if you're designing it to reveal things about not just the individual case and the individual person who's a prosecutor, but about the office and the office policy and the shaping force of the office culture. So what I'm excited about, interested in, starting in 2017 going forward, is using that kind of real, starry-eyed technology for something that is going beyond reconstructing individual cases, but is using that to spot trends and to have internal discussions about what we are doing in our prosecutor office, but also to have the external conversations. How is it that we could create better public safety by not just spending our time in the courtroom, but engaging with aspects of criminal justice and public safety that create upstream from the courtroom and downstream from the courtroom the better public safety results that I think prosecutors can participate in, even when they're not working on the one file that's in the courtroom that's in the case. So that's the vision of prosecutorial record, or prosecution on the record, that strikes me as the most promising going forward from this 50-year mark from the 1967 vision of recording what happened from one person in one case. I'll leave it at that. Thank you.
Okay, so we have only about 5 minutes for questions, so I think we can take 1 or 2 questions from the audience, short questions from the audience. Yes?
A little bit longer, but has anybody thought about the concept of a balanced trial, where you have a case where in every single court case it's mandated that if a prosecution gets a certain resources to argue their side of the case, it had requirements that the defense also is entitled to the same resources, remuneration requirements, rules, and rights that the prosecution has in the case, and that both sides are ethically obligated to make sure that the evidence in their side is as accurate as possible at getting at the truth of the case, and no whitewashing or sabotaging the evidence that could destroy accuracy in any kind of verdict. Has anyone thought about making that a government mandate, that trials be balanced in that way, and that it be no longer private defense, but every single defendant gets the same type of defense regardless of socioeconomic status? Have you ever thought about something like that for?
Would person like to respond to this question?
There was a lot there, a lot of different things there. I certainly am for every person who is standing trial having adequate resources to, I'm all for that. We strive for that world where that all happens. But you mentioned some other things about balance. I mean, the role of the prosecutor is simply different from the role of the defense. And so prosecutors have the burden of proof, defendants don't. And so for those reasons, like everything can't and shouldn't be equal in that sense. And so in other words, you shouldn't put same responsibilities on the defense that you have on the prosecutor, because they just have very, very different roles that I don't have time to explain, but that would be my short answer to that.
Tracy?
So my question is short, and I thought of it when Angela was speaking about her 2 recommendations, the first of which was to encourage prosecutors to, I think, either divert or decline, I think you said nonviolent offenders. And I was like, well, if we're going to deal, if mass incarceration is your problem, then we have to deal with people who commit violent offenses. Yes. I don't like violent offender. And then Danny made that point. So I just wanted to know what you thought when he said that.
No, I agree with them on that we can't. So first of all, when I wrote about this in an article about a year ago, I say as a start, let's say all nonviolent, which people push back on huge, because I always get the Bernie Madoff question, like, what about Bernie Madoff? I'm like, yeah, Bernie too, let him out, he can pay other ways, in other ways that pay the people back, right? So my answer to that is I absolutely agree. We have to deal with the violent offenses, absolutely, and my answer is the same as yours, Danny, is that we have to talk about lighter, not these extraordinarily harsh sentences. Like, there are people who commit violent offenses who become nonviolent and non-dangerous after a certain period of time. And so I think we have to look to what European countries are doing. I think there's something like a 21-year, what am I thinking about? Like, Jeremy Travis did some work on this, where they went and they traveled to these European countries and they found that there's
I think Norway has like 15, but then you read the fine print, which is that after you get out of jail, they can hold you indefinitely for public safety reasons.
Yeah, they can.
outside of jail, hold you somewhere else.
Hold you in a, not punishment, but in a regulatory.
Right.
Not
So
in a
my
loving way.
so my answer to your question is we do have to not only address what I'm saying, but we have to start with something that the public can find, and they don't even find. I have found people pushing back hard on my very modest proposal. So that's why I don't use it. The other piece of it too is that every crime that's called a violent crime isn't actually a violent crime. There are some jurisdictions that sort of characterize certain crimes. Like, I don't consider unarmed burglary to be a violent crime. It's not a crime against persons. That's a crime. That robbery is a crime against persons, but an unarmed burglary where no one is home, in my opinion, is not a violent offense. Yet some jurisdictions characterize it that way. And there are some people who are convicted of violent offenses who are not violent people, right? The person who was the juvenile, getaway lookout, who did not handle the gun, but technically, because they're an aider and abetter, is, in my opinion, not a dangerous, violent person like the person who held the gun. And so my point is that I think, yes, I agree we need to go beyond nonviolent, and I would put in that category some of the cases that I've just described. But I think you have to start somewhere, and we're far from even what I consider to be modest proposals. So.
Well, please join me in thanking this great panel.